Case 1, Jocelyn Ortega, October 25, 2012, started like countless other autumn days on Manhattan's Upper West Side. Marina Krim, a stay-at-home mother and former teacher, prepared to take her 3-year-old daughter Nessie to a swimming lesson at a nearby YMCA. Her 2 other children, 6-year-old Lucia and 2-year-old Leo, would remain at the family's apartment in the La Rochelle building with their nanny, Jocelyn Ortega. The arrangement was routine. Ortega had worked for the Krim family for more than 2 years. They had trusted her so completely that they paid for her trips back to the Dominican Republic and even vacationed with her there 9 months earlier. By all outward measures, she seemed devoted to the children. Marina had arranged to meet Ortega and Lucia at the 6-year-old's dance class later that afternoon, around 5:30 p.m. When Ortega failed to arrive on time, Marina grew concerned. She tried calling and texting the nanny, no response. Marina returned to the apartment with Nessie to check on her children. The lights were off when she opened the door. The eerie quiet puzzled her. She returned to the lobby and asked the doorman if he had seen the children leave. He had not. Marina went back upstairs and began searching the darkened apartment. She walked toward the back bathroom. When she opened the door, she discovered a scene of unimaginable horror. Lucia and Leo lay in the bathtub, their small bodies covered in blood. Their eyes were open. Lulu had been stabbed more than 30 times. Leo's small body bore 5 stab wounds. Both children were already dead or dying. Ortega sat on the bathroom floor next to the tub, a kitchen knife in her hand, her own throat and neck bleeding from self-inflicted wounds in what appeared to be a failed suicide attempt. Marina grabbed Nessie and ran to the hallway landing outside the apartment. She began screaming. The sound that came from her, she would later testify, was something she did not know existed inside her. Neighbors called 911. First responders arrived within minutes, but there was nothing they could do. Lucia and Leo were pronounced dead. Ortega was rushed to the hospital, where she survived her injuries. Kevin Krim, the children's father, was on a business trip and flying home from the West Coast when police reached him at John F. Kennedy International Airport. He learned in that moment that his 2 children were dead. He would later speak of walking down a long hospital hallway to see their bodies, a journey no parent should ever have to make. The investigation quickly revealed troubling information about Ortega. She had been hired based on a recommendation from her sister, who also worked as a nanny for another New York family. But prosecutors would later discover that Ortega's family had fabricated her background and references to make her appear qualified for the position. The deception worked. The Krims hired her, welcomed her into their home, and entrusted her with their children's lives. During the trial that followed years later, prosecutors argued that Ortega had grown jealous of Marina Krim's lifestyle and resentful about her wages. The Krims had been generous employers who treated Ortega well, even paying for her travel. Yet something festered inside her. On that October afternoon, while Marina took Nessie to swim lessons, Ortega carried out a brutal attack on the 2 children left in her care. Ortega's defense team argued she was mentally ill and could not be held responsible for her actions. They portrayed her as suffering from undiagnosed depression and anxiety that her family had hidden from the Krims. During the 7-week trial in March 2018, jurors heard heart-wrenching testimony from Marina Krim. She described coming home to the eerily quiet apartment and opening the bathroom door to find her children's vacant eyes staring back at her, their small bodies covered in blood. She spoke of clutching Nessie and screaming, a sound she described as coming from somewhere she did not know existed within her. The jury was not persuaded by the insanity defense. On April 18, 2018, after deliberating for more than a day, they found Ortega guilty on all counts, 2 counts of first-degree murder and 2 counts of second-degree murder. Ortega showed little emotion as the verdict was read, staring straight ahead while a row of court officers stood watch behind her. At her sentencing hearing on May 14, 2018, both Marina and Kevin Krim delivered emotional victim impact statements. Marina told the judge that Ortega had destroyed her own family through her actions, noting that Ortega had shown no remorse and no one in her family had ever apologized. She said through tears that while Ortega may have thought she destroyed Lulu and Leo, she failed. They remained powerful forces, two stars who would always lead the family forward. Kevin Krim was even more direct. He eviscerated Ortega for not pleading guilty and forcing the case into a courtroom, putting the family, jurors, and audience through the ordeal of a trial. He described the defendant as an evil and utterly dangerous narcissist. It was right, he said, that she should live and rot and die in a metal case, like the ugly and dark shadow of Lulu and Leo's bright and shiny lights. Judge Gregory Caro referred to Ortega as pure evil before sentencing her to life in prison without the possibility of parole. The 55-year-old woman will spend the rest of her life behind bars. But the case revealed a troubling gap in the law. Because Ortega's family had lied about her background and fabricated references, Kevin Krim noted at sentencing they bore responsibility for putting a dangerous person in contact with vulnerable children. Yet they faced no legal consequences. No law existed to hold them accountable for their deception. The Krims channeled their grief into advocacy. They pushed for legislation to make it a crime to falsify job applications and references for someone working in child care. In direct response to their children's murders, a bill called Lulu and Leo's Law was introduced in the New York State Legislature. The law eventually passed, creating criminal penalties for falsifying credentials in child care positions. At the bill signing, Kevin Krim stated that they had hired the woman who murdered their children based on a deliberate set of lies, and thanks to the new law, there would now be a strong deterrent to that kind of deception. The family also created the Lulu and Leo Fund, a nonprofit charity providing creative education programs for disadvantaged children through an initiative called Choose Creativity. The fund was, in Kevin's words, an act of positive defiance. By 2014, it had served 2,300 children. The Krims post photos and memories of their children on the fund's public Facebook page, including fundraising events and artwork created by Lulu and Leo. Since the murders, Marina and Kevin have had two more children, Felix and Linus, who make appearances in videos related to the fund. The case attracted international attention. French-Moroccan writer Leila Slimani wrote a novel inspired by the killings called Chanson douce in French, published as Lullaby in the UK and The Perfect Nanny in the United States. The book was well received in France, winning the prestigious Prix Goncourt in 2016, though it did not achieve similar success in America. Yoselin Ortega remains in a New York State prison, serving life without the possibility of parole. The name Ortega became associated with one of the most shocking acts of violence by a trusted caregiver in recent memory. Marina Krim's final words before finding her children were to remind them that Lulu and Leo would always be with them. Even today, more than a decade later, the case continues to influence discussions about caregiver vetting, background checks, and the sacred trust placed in those who care for our most vulnerable. The devastation forced uncomfortable truths into public conversation. How do families protect their children when even thorough vetting fails? What responsibility do we bear to ensure honesty in the hiring process? And how do we honor the memory of children whose lives were stolen by someone who should have protected them? Lucia and Leo Krim did not live to see their next birthdays, but through their parents' determination, their legacy extends far beyond the tragedy that took their lives. Case 2. Christine Falling. Christine Laverne Slaughter was born on March 12, 1963, in Perry, Florida, into circumstances that offered little hope for a normal life. Her mother, Anne, was only 16 years old. Her father, Thomas, was 65, a woodsman who proved both inattentive and violent. The family lived below the poverty line, and Christine did not receive the early childhood support she desperately needed. She was considered mentally challenged and suffered from epilepsy. When her parents could no longer afford to support her and their constant arguments made home life unbearable, Christine and her older sister spent portions of their childhood in various orphanages. From an early age, Christine demonstrated violent tendencies. She began killing small animals, especially domestic cats. She would strangle them or drop them from heights, later justifying her actions by saying she wanted to test their 9 lives. This disturbing behavior should have served as a warning. Instead, it went largely unaddressed. At 14, in September 1977, Christine's parents forced her into marriage with a 20-year-old man. The union lasted only 6 weeks, marked by almost daily quarrels and physical altercations before ending in divorce. What followed were years of unexplained medical complaints. Over the next 2 years, Christine was hospitalized 50 times, but doctors were unable to find any treatable conditions. She suffered from hallucinations and complained of red dots appearing before her eyes. At 16, she was diagnosed as medically incapacitated. Despite her troubled history and documented disabilities, Christine Falling began working as a babysitter for neighbors and friends. She needed money, and babysitting seemed like simple work. What no one realized was that they were handing their children to someone whose violent impulses had never been properly addressed. On February 25, 1980, 2-year-old Cassidy Johnson was sent to a doctor's office in Blountstown, Florida. She was diagnosed with encephalitis. 3 days later, on February 28th, Cassidy died. An autopsy listed the cause of death as blunt force trauma to the skull. Falling, who had been babysitting for Cassidy, claimed the child had passed out and fallen from her crib. The attending physician did not believe Falling's story and wrote a note recommending police investigate her. That note was lost. The case was closed. Shortly after Cassidy's death, Falling moved to Lakeland, Florida. 2 months later, in early summer 1980, 4-year-old Jeffrey Davis died while under her supervision. An autopsy pointed to myocarditis, a heart condition that is rarely fatal, as the cause of death. No one connected Jeffrey's death to the earlier incident with Cassidy Johnson. 3 days after Jeffrey's funeral, the Davis family asked Falling to watch Jeffrey's cousin, 2-year-old Joseph Spring. He died within hours. Doctors diagnosed a viral infection as the cause. They noted the virus may have caused Jeffrey's death as well. The medical community accepted this explanation. No investigation was launched. No one questioned why children kept dying in Christine Falling's care. In July 1981, Falling left Lakeland and returned to her hometown of Perry in northern Florida. She found work as a housekeeper for 77-year-old Wilbur Swindle. On her first day of work, Swindle suddenly died in his kitchen. Due to his advanced age and deteriorating health, no suspicions arose. The death was attributed to natural causes. Falling's next victim was her 18-month-old niece, who allegedly stopped breathing while under Falling's care. Once again, and for what would prove to be the last time, the killer escaped apprehension. The deaths were piling up, but each was viewed in isolation rather than as part of a pattern. By this time, Falling had been present for the deaths of at least 5 children and 1 elderly man over the span of 2 years. Yet she remained free. The deaths had occurred in different jurisdictions. Each had plausible alternative explanations. Young children and elderly people die of natural causes. Medical examiners did not communicate across county lines about unusual patterns. No central database tracked babysitters linked to multiple child deaths. The pattern finally broke in July 1982. 10-week-old Travis Dwayne Coleman stopped breathing while Falling was caring for him at her mobile home in Blountstown. This time, an autopsy was requested. Medical examiners discovered the infant had died from suffocation. The finding of internal injuries consistent with smothering could not be explained by natural causes or accident. Authorities immediately questioned Falling. Under interrogation, she confessed to murdering 3 children by what she described as smotheration. She claimed she had heard voices ordering her to kill the babies. The voices told her to place blankets over their faces. She said she killed them to prevent anyone from hearing them scream. Falling was arrested and charged with murder. Prosecutors had to decide which cases to pursue. They focused on the deaths where evidence was strongest: Cassidy Johnson and Travis Coleman. In exchange for avoiding the death penalty and not being charged in the other deaths, Falling entered guilty pleas in December 1982. On December 3, 1982, in Calhoun County Circuit Court in Blountstown, the 19-year-old stood before Judge Larry A. Botiford and pleaded guilty to the murders of Johnson and Coleman. The following day, she appeared before another judge in a separate county and pleaded guilty to a third murder. Botiford immediately sentenced Falling to 3 concurrent life terms with eligibility for parole after 25 years. Her stepfather, Jesse Falling, who had adopted her at age 4, remained bewildered even after her conviction. He insisted she was a lover of children. He could not reconcile the person he thought he knew with the crimes she had committed. Falling was transferred to prison to begin serving her sentence. Over the decades that followed, she became eligible for parole, but was denied repeatedly. At her parole hearing in 2017, prosecutors told the review panel that the so-called babysitter from hell deserved no mercy. The request for parole was rejected. Her presumptive release date was set for the year 2254, long after she will have died. The case of Christine Falling raised troubling questions about how society protects its most vulnerable. A teenage girl with documented mental disabilities, a history of animal torture, and 50 psychiatric hospitalizations had been allowed to work as a babysitter. No system existed to prevent someone with her background from gaining access to children. No agency tracked patterns of child deaths across jurisdictions. The attending physician who suspected Falling after Cassidy Johnson's death had tried to sound the alarm. His note recommending investigation was lost in bureaucratic shuffle. Had it been acted upon, 4 more children and an elderly man might have lived. The system failed at multiple points. Falling's case also highlighted how easily deaths of very young children can be attributed to natural causes. Sudden infant death syndrome, viral infections, heart conditions, and accidents all provide plausible explanations. Without careful investigation and pattern recognition, a killer can operate for years, moving from town to town, leaving a trail of small bodies behind. The voices Falling claimed to hear were never verified. Some questioned whether she invented the auditory hallucinations to support an insanity defense. Mental health experts who evaluated her found she knew right from wrong when she committed the murders. Her motive remains unknown. She never expressed remorse or offered a coherent explanation beyond the voices. What is known is that between February 1980 and July 1982, at least 6 people died in Christine Falling's care. She suffocated children with blankets and pillows while their parents trusted her to keep them safe. She killed her own niece. She killed an elderly man on her first day as his housekeeper. Each death was initially accepted as natural or accidental until the pattern became too obvious to ignore. Christine Falling remains imprisoned in Florida. She is now in her 60s, having spent most of her adult life behind bars. The families of her victims have lived with their losses for more than 4 decades. The case continues to serve as a cautionary tale about the importance of background checks, cross-jurisdictional communication, and taking seriously the warning signs that appear before tragedies occur. Even today, the question raised across Florida in the wake of the deaths remains relevant. Can you trust your babysitter? The answer depends on systems working properly, on thorough vetting, on doctors' notes not being lost, and on society taking seriously the vulnerabilities of those who cannot protect themselves. Case 3. Kimora Hodges. On June 13, 2022, a 22-month-old boy was dropped off at a home in Roseville, Michigan, a suburb north of Detroit in Macomb County. His parents trusted Kimora Lame Hodges, a 22-year-old woman, to care for their toddler while they worked. What they did not know was that Hodges was already facing criminal charges for abusing another child. Despite this pending case, she continued to babysit. By the end of that day, the little boy would be fighting for his life. The details of what happened inside that home remain partially shielded by the clinical language of court documents and medical reports. Prosecutors alleged that Hodges physically harmed the child with such force that he sustained catastrophic injuries. Medical staff who examined him at the hospital found a subdural hemorrhage, bleeding between his skull and brain. He also had bilateral retinal hemorrhages, bleeding in both eyes. These injuries indicated severe head trauma. The boy was rushed to an area hospital, but the damage was too extensive. He died from his injuries. An investigation was immediately launched, and Hodges became the focus of scrutiny. What emerged during the investigation was deeply troubling. This was not the first time a child had been seriously injured in Hodges' care. Prosecutors had already charged her with child abuse in a separate incident. That case involved another young child who had sustained injuries while under Hodges' supervision. The legal system was aware that Kimora Hodges posed a danger to children, yet somehow she continued to have access to vulnerable toddlers. The failure was systemic. When someone is charged with child abuse, mechanisms should exist to prevent them from continuing to work with children while the case is pending. Parents should be informed when a caregiver has allegations against them. Warning systems should trigger. In this case, those protections either did not exist or were not implemented. A 22-month-old boy paid for that failure with his life. Macomb County prosecutors moved forward with serious charges against Hodges. She was charged with felony murder and first-degree child abuse. The felony murder charge reflected the fact that the child died during the commission of another felony, the child abuse. Under Michigan law, this carries a mandatory sentence of life in prison without the possibility of parole. The case went to trial in July 2025, 3 years after the toddler's death. Over 6 days, jurors heard evidence about the injuries the child sustained and the circumstances surrounding his death. Prosecutors presented medical testimony explaining how the subdural hemorrhage and retinal hemorrhages occurred. These injuries do not happen from minor falls or accidents. They require significant force. On July 31, 2025, the jury returned guilty verdicts on both counts. Kimora Hodges was convicted of felony murder and first-degree child abuse. The verdict meant she would face the harshest penalty available under Michigan law. The sentencing hearing took place on November 5, 2025. Macomb County Prosecutor Peter J. Lucido stood before the court and addressed the gravity of what had occurred. He emphasized that the sentence reflected the severity of the crime committed. The defendant's actions resulted in the tragic death of an innocent child, and the court imposed a life sentence without the possibility of parole to hold her fully accountable. Lucido went further, speaking to what the case represented beyond one defendant and one victim. He stated that the justice system has a duty to protect the most vulnerable members of society, and the sentence underscored that duty. His thoughts, he said, remained with the victim's family, whose lives had been forever changed by this senseless act. The judge sentenced Hodges to life in prison without the possibility of parole on the felony murder conviction. Additionally, she received 15 to 40 years for the first-degree child abuse charge. The sentences were ordered to run consecutively, meaning one after the other. Given that the first sentence was life without parole, the additional years served primarily as a symbolic statement about the severity of what she had done. Kimora Hodges was 24 years old at sentencing. She will spend the rest of her life in a Michigan prison. She will never have the opportunity to harm another child. But for the family of the 22-month-old boy, the conviction and sentence brought no real comfort. Their son would never take another step, never speak another word, never grow beyond his second year of life. They had trusted someone to care for him, and that person killed him. Worse still, warning signs had existed. The system knew Hodges was dangerous, yet their child was placed in her care anyway. The case raised difficult questions about accountability and prevention. How does someone facing child abuse charges continue to babysit? Are parents informed when caregivers have pending criminal cases? What background check systems exist, and do they include pending charges or only convictions? If a caregiver is out on bond awaiting trial for harming a child, should that person be legally prohibited from caring for other children? These questions have no easy answers, but the stakes could not be higher. Children cannot advocate for themselves. They cannot research their caregivers' backgrounds or demand to see criminal records. They are entirely dependent on the adults around them and on the systems those adults create to keep them safe. The tragedy in Roseville demonstrated what happens when those systems fail. A child died because someone who should never have been near children was allowed to continue babysitting. The legal system responded with the maximum penalty available, but that response came too late for the little boy who lost his life on June 13, 2022. Macomb County officials have since emphasized their commitment to protecting vulnerable residents. The prosecutor's office has worked to hold accountable those who abuse positions of trust. But the fundamental problem remains: how do we prevent dangerous people from accessing victims in the first place? The answer requires coordination between law enforcement, the courts, child care agencies, and parents. Background checks must be thorough and current. Pending charges must be disclosed. Legal restrictions on contact with children must be enforced. And parents must have access to information about the people caring for their children. None of these measures would be complicated to implement. None would require revolutionary changes to existing systems. Yet in June 2022 in Roseville, Michigan, they were not in place or were not functioning. A 22-month-old boy died as a result. Kimora Hodges will spend her life in prison, but that outcome does nothing to address the preventable nature of the tragedy. The case stands as a stark reminder that protecting children requires more than punishing those who harm them after the fact. It requires preventing harm before it occurs, even when that means difficult conversations about oversight, monitoring, and restricting the freedoms of those who pose dangers to the vulnerable. The little boy in Roseville deserved that protection. He did not receive it. Case 4. Lauren Courtney Ryan Peralto was 5 years old and living in Las Vegas with his father and sister. His father worked to support the family and needed someone to watch the children while he was away. He hired Lauren Courtney, a 23-year-old woman, to babysit. What seemed like a practical arrangement would end in tragedy. Ryan's older sister began telling her father that Courtney was hurting Ryan. The girl's reports were specific enough that her father took them seriously. He made a decision that would later prove crucial. He installed surveillance cameras throughout the home. He wanted to see what was happening when he was not there. He wanted to know if his daughter's concerns were justified. In November 2021, those cameras captured something no parent should ever have to witness. The footage showed Lauren Courtney attacking Ryan in a sustained, brutal assault that lasted approximately 2 minutes. The video evidence was so clear and so devastating that it would become the centerpiece of the prosecution's case. The attack began in one room and continued as Courtney dragged Ryan into a bathroom. She was screaming at him, yelling about her bad day and how he was upsetting her. The 5-year-old was vomiting. Blood came from his mouth. He was clearly in distress, his small body unable to withstand the violence being inflicted upon him. Courtney kicked his head while he lay on the floor. She squatted down over him, continuing to scream. At one point, she turned on the shower and left the bathroom while the child could be heard crying and moaning. After the assault, Courtney placed Ryan on the couch. She left him there, suffering and dying, for approximately an hour to an hour and a half. She did not call for help. She did not attempt to provide medical care. She did not contact Ryan's father. She simply went about her business while the 5-year-old boy lay on the couch with catastrophic injuries. When Ryan's father returned home, he found his son unresponsive. Emergency services were called immediately, but it was too late. Ryan was pronounced dead. Medical examiners determined he had suffered a skull fracture, a brain bleed, and a fractured spleen. The Clark County Coroner's Office ruled his death a homicide due to blunt force injuries to the head, chest, and abdomen. The surveillance footage left no room for doubt about what had happened or who was responsible. Police arrested Lauren Courtney and charged her with murder. During questioning, she claimed she could not remember how the child was injured while in her care. She acknowledged knowing there were surveillance cameras in the home. Her claims of memory loss were contradicted by the video evidence showing her sustained attack on the helpless child. At some point during the investigation or legal proceedings, someone associated with Courtney's defense attempted to argue she had been sleepwalking during the attack. Deputy District Attorney Gianna Job called this claim offensive during later court proceedings. She questioned the credibility of anyone suggesting that what the video showed was anything other than deliberate violence. Faced with overwhelming evidence, Lauren Courtney entered a guilty plea in October 2022. By pleading guilty, she avoided a trial where prosecutors would have presented the full video evidence to a jury. She also avoided the possibility of a harsher sentence. The sentencing hearing took place on December 14, 2022. Deputy District Attorney Job stood before the court and described what Ryan had endured. She emphasized that it was very clear Ryan had been a happy 5-year-old child. She detailed how Courtney dragged him around the house while he was vomiting blood, yelling at him and screaming about her bad day and her problems. Then she left him on the couch for more than an hour, where he lay suffering and dying, because she did not do anything to get him medical care. Judge Michelle Levitt sentenced Lauren Courtney to life in prison with the possibility of parole after 20 years. Under Nevada law, this meant Courtney would serve a minimum of 20 years before becoming eligible to appear before a parole board. If she is denied parole, she will remain imprisoned. She will not automatically be released after 20 years. Courtney addressed the court at sentencing and asked the Peralto family for forgiveness. She read from a letter expressing her sorrow and remorse, stating she wished she could do more to convey how sorry she was. The words rang hollow, given what the video evidence had captured. Her remorse came only after being caught, charged, and convicted. Lauren Courtney is currently serving her life sentence in a Nevada prison. She will become eligible for parole in 2042, when she will be in her mid-40s. Whether she will ever be released depends on the parole board's assessment of whether she poses a continuing danger to society. For Ryan Peralto's family, no sentence could restore what was taken from them. Ryan will never grow up, never attend school, never celebrate another birthday. His father made the painful decision to install cameras after his daughter's warnings, and those cameras captured the last moments of his son's life. The footage provided justice in the form of a conviction, but it also documented horror that will haunt the family forever. The case demonstrated the importance of listening to children when they report abuse. Ryan's sister tried to tell her father what was happening. Her father believed her and took action by installing cameras. That decision meant Ryan's killer could not escape accountability. In too many cases, children's reports are dismissed or minimized. Ryan's father showed what can happen when adults take children's concerns seriously. The surveillance footage also eliminated any possibility of Courtney claiming the injuries were accidental. There could be no argument about what happened. The video showed a sustained attack on a defenseless child, followed by deliberate neglect as he lay dying. It showed Courtney's rage directed at a 5-year-old boy who had no way to protect himself. Cases like Ryan Peralto's force difficult questions about who we trust with our children. Background checks can reveal criminal history, but Lauren Courtney had been hired without apparent red flags. Her violence emerged in the privacy of the home, behind closed doors, directed at a child too young to effectively defend himself or escape. Only the cameras and his sister's bravery in speaking up revealed the truth. Ryan Peralto was 5 years old when he died on a couch in Las Vegas, left there by the person who was supposed to keep him safe. The surveillance cameras his father installed told the story of what happened to him. Lauren Courtney will spend decades in prison for what she did, but Ryan will never have the chance to grow up. His case remains a reminder of the vulnerability of children and the devastating consequences when the people entrusted with their care become their killers. Case 5. McCallie-Durham, Corinth, Mississippi, is a small city in the northeastern corner of the state near the Tennessee border. In September 2022, a family there made a decision that parents across the country make every day. They hired a babysitter to watch their 2 young children. The children were an 11-month-old baby girl and her 2-year-old brother. The babysitter was 25-year-old McCallie Elizabeth Durham, a local resident. What happened next would destroy one young life and leave another child bearing the scars of violence. On September 15, 2022, investigators were notified that the 2-year-old boy had died from his injuries. The 11-month-old girl remained hospitalized but in stable condition. Both children had been in Durham's care when they sustained their injuries. The details of what Durham did to these children were severe enough that prosecutors immediately began building a case for the most serious charges available under Mississippi law. Investigators discovered that Durham had a misdemeanor warrant outstanding at the time she was caring for the children. This fact, while seemingly minor, raised troubling questions. A person with an active warrant was entrusted with the care of 2 vulnerable children. Whatever screening process existed had failed to identify this red flag. The 2-year-old boy's injuries proved fatal. Medical examiners determined his death resulted from trauma sustained while in Durham's care. The 11-month-old girl survived, but she had been assaulted as well. The fact that Durham harmed both children suggested this was not an isolated moment of lost control. It indicated a pattern of violence directed at helpless victims. Alcorn County authorities moved quickly. Durham was taken into custody and transported to the Alcorn County Jail. She was charged with capital murder for the death of the 2-year-old boy and felony child abuse in relation to the assault on the 11-month-old girl. Under Mississippi law, capital murder carries either the death penalty or life imprisonment without the possibility of parole. The case moved through the legal system over the following 2 years. In December 2024, McCallie-Durham stood before Circuit Judge Michael P. Mills, Jr. and entered guilty pleas. She pleaded guilty to capital murder and to 4 counts of felony child abuse. By pleading guilty, she avoided a trial where prosecutors would have presented evidence of what she did to 2 defenseless children. Judge Mills imposed the maximum punishment available. Durham was sentenced to life imprisonment in the custody of the Mississippi Department of Corrections for the capital murder conviction. She received an additional 40 years for the child abuse charges. The judge made clear that Durham would not be eligible for parole or any other form of release from incarceration. She would spend the rest of her natural life in prison. The case was prosecuted by Assistant District Attorneys Kyle Robbins and Clay Cummings. They had presented the charges to a grand jury and secured the indictments necessary to move forward. When Durham entered her guilty pleas, they ensured the sentencing reflected the severity of what she had done. The family of the victims faced an unimaginable reality. Their 2-year-old son was dead, killed by the person they had trusted to keep him safe. Their infant daughter survived, but had been harmed by the same person. The 11-month-old girl would grow up without her brother and with whatever physical and emotional trauma resulted from the abuse she endured. The dual nature of Durham's crimes set this case apart. She did not lose control in a single moment with one child. She harmed both children in her care. This suggested deliberate violence rather than an accident or a momentary lapse. It demonstrated a willingness to inflict pain on the most vulnerable victims imaginable, a toddler and an infant who could not fight back, could not escape, and could not protect themselves. Cases involving harm to multiple children in the same family carry particular horror. Parents must grapple not only with the death of one child, but also with knowing their other child was harmed by the same person at the same time. Siblings are supposed to protect each other as they grow up, but in this case, the 2-year-old could not protect his baby sister, and she could not save him. Both were entirely at the mercy of McCallie Durham, and she showed them none. The maximum sentence imposed by Judge Mills reflected society's judgment that some crimes are so severe and some offenders so dangerous that they must be permanently removed from the community. Durham will never again have access to children. She will never again be in a position to harm the vulnerable. She will grow old and die in a Mississippi prison. For the surviving child, life will continue, but with the shadow of what happened in September 2022. She will learn as she grows older that her brother died and that she was harmed by the same person. She will carry questions about why it happened and what her brother was like. Her parents will bear the burden of explaining the inexplicable, that evil sometimes wears the face of a trusted caregiver. The case in Corinth joined the long list of tragedies involving babysitters who betrayed the trust placed in them. It demonstrated once again that the most dangerous violence is not always committed by strangers on dark streets. Sometimes it happens in familiar homes during daylight hours by people who were invited in and given access to those least able to defend themselves. McCallie Elizabeth Durham is now a number in the Mississippi Department of Corrections system. She is serving life without parole plus 40 years. The little boy she killed will never become a teenager, never graduate from school, never have children of his own. His sister will grow up without him, marked by injuries sustained before she was even a year old. The family will never fully heal from what was taken from them on that September day in 2022. The judge's sentence sent a clear message. Those who harm children will face the full weight of the law. But for the family left behind, no sentence can restore what was lost or undo the trauma that was inflicted. Justice was served in the courtroom, but the real cost of McCallie Durham's crimes will be paid by her victim's family for the rest of their lives. Case 6. Malakiri Kennedy Trinity. Kyles was 2 years old and living with her mother and her mother's boyfriend, Malakiri Kennedy, in a hotel room in Duluth, Georgia, part of Gwinnett County. Her mother worked to support the family and needed someone she could trust to watch Trinity while she was away. She turned to Kennedy, her romantic partner, believing he would keep her daughter safe. It was a decision made by countless mothers who must balance earning a living with caring for their children. It was a decision that would cost Trinity her life. On May 2, 2021, Trinity's mother left for work, asking Kennedy to watch her daughter. He was 24 years old at the time and had been in a relationship with Trinity's mother. The little girl was left in his care in the confined space of the hotel room. No one else was present. Whatever happened that day, only Kennedy and Trinity would know. When Trinity's mother returned from work, she found her daughter unresponsive and not breathing. She immediately called 911. The fire department responded and attempted to revive the child. Their efforts failed. Trinity was pronounced dead at the scene. Medical examiners who examined Trinity's small body found disturbing evidence of trauma. She had several bruises on her cheeks, and these bruises bore the distinctive marks of fingers and fingernails. Someone had gripped her face with enough force to leave impressions. Her forehead was swollen. Additional bruises covered her body. These were not injuries from a fall or an accident. They were injuries consistent with being struck and gripped by an adult. Investigators questioned Kennedy about what happened. His initial story was that he had given Trinity melatonin to help her sleep. He claimed the child must have had some kind of reaction, or that something unexpected had occurred. His explanation did not match the physical evidence. The bruises, the fingernail impressions, the pattern of injuries all told a different story. Under continued questioning, Kennedy eventually confessed. He admitted to pinching Trinity. The confession aligned with what medical examiners had found, evidence that someone had used their fingers to inflict pain on the 2-year-old. But the injuries were more extensive than simple pinching might suggest. Trinity had sustained trauma severe enough to cause her death. Kennedy was arrested and charged with murder. Gwinnett County prosecutors built their case around the physical evidence and Kennedy's own confession. They charged him with malice murder, meaning he killed Trinity with malice aforethought. They also charged him with 2 counts of felony murder, reflecting that Trinity died during the commission of other felonies, aggravated battery, and first-degree cruelty to children. The case went to trial exactly 3 years after Trinity's death. On May 2, 2024, a Gwinnett County jury heard the evidence against Malik Kyrie Kennedy. They learned about the bruises on Trinity's face bearing his fingernail marks. They heard about the swollen forehead and the other injuries. They heard his initial lies and his eventual confession. They saw photographs of a 2-year-old girl who should have been protected, but instead was killed by the man her mother trusted. The jury found Kennedy guilty on all counts: malice murder, 2 counts of felony murder, aggravated battery, and first-degree cruelty to children. The verdict came on the 3-year anniversary of the day Trinity died. After the jury returned with their decision, the judge immediately sentenced Kennedy to life in prison without the possibility of parole. Kennedy was 27 years old at sentencing. He will spend the rest of his life in a Georgia prison. He will never be released. He will never have the opportunity to harm another child. For Trinity's mother, the conviction brought no comfort. She had trusted Kennedy with the most precious thing in her life. She had left her daughter in his care while she went to work to support them. She came home to find Trinity dead and the man she trusted responsible for killing her. The betrayal was complete. He had not only taken her daughter's life, but had destroyed the trust she placed in him as her partner. The case highlighted a danger that exists in households across the country. Single mothers often rely on romantic partners to help with childcare. These arrangements seem practical and necessary. The mother needs to work, and the boyfriend or partner is already living in the home. It feels safer than leaving children with strangers. But when that trust is misplaced, the consequences can be fatal. Kennedy's case demonstrated how domestic arrangements can create opportunities for violence against children. Trinity was alone with him in a hotel room. No one else was there to witness what happened or to intervene. Her mother was at work, trying to provide for her family. The 2-year-old was entirely dependent on Kennedy's care, and he used that isolation to harm her. The pattern of injuries suggested sustained abuse rather than a single moment of violence. The bruises on her cheeks, with fingernail impressions, indicated he had gripped her face. The swollen forehead suggested impact. The other bruises across her body painted a picture of a child who had been subjected to physical abuse before the final fatal assault. Kennedy's initial lie about giving Trinity melatonin showed consciousness of guilt. He knew immediately that he needed to provide an explanation for her condition and her death. He tried to create a narrative that did not involve his violence. Only when confronted with the evidence and continued questioning did he admit to what he had done, though even his confession likely minimized the full extent of the abuse. The hotel room setting added another layer of tragedy to the case. This family was not living in a stable home, but rather in temporary housing. Whatever circumstances had led them to that situation, they were clearly struggling. Trinity's mother was working to try to improve their situation. She was doing what she needed to do to take care of her family. And in her absence, the man she relied on killed her daughter. Gwinnett County has seen its share of child abuse cases, but Trinity Kiles's death stood out for the betrayal it represented. This was not a stranger who harmed a child. It was not even a hired babysitter with a hidden history. It was the mother's boyfriend, someone who had a relationship with the family, someone who should have had a vested interest in Trinity's well-being. Malakiri Kennedy is now serving life without parole in a Georgia prison. He will never see freedom again. He will grow old behind bars, knowing he killed a 2-year-old girl who called him by name and trusted him. Trinity Kiles will remain forever 2 years old, her life cut short by someone who was supposed to protect her. The case serves as a warning about the dangers children face, even in seemingly familiar circumstances. Background checks cannot predict how someone will behave behind closed doors. Previous good behavior does not guarantee future safety, and the people closest to children are sometimes the ones who pose the greatest danger. Trinity's mother learned these lessons in the cruelest way possible, and her daughter paid the ultimate price. Case 7. Victoria Fox. A San Diego couple was expecting twins through a surrogate. They already had a 4-week-old son named Phoenix. With twins on the way and an infant at home, they knew they needed help. They decided to hire a second nanny, someone with experience who could handle the demands of caring for multiple young children. They wanted to do everything right. The couple did not cut corners. They fully vetted their candidates. They checked references. They conducted interviews. They were careful and thorough because they understood the responsibility of bringing someone into their home to care for their children. After their screening process, they selected Victoria Fox, a 40-year-old woman who presented herself as an experienced caregiver. They were confident in their choice. They flew Fox to San Diego and welcomed her into their home. Fox spent several days with the family. During this trial period, she was never left completely alone with the children. The parents were present, observing how she interacted with Phoenix, evaluating her skills and her temperament. Everything seemed fine. Fox appeared competent and caring. The parents felt reassured. Their vetting process seemed to have worked. Then came the day the surrogate went into labor. The parents needed to go to the hospital for the birth of their twins. It was the first time Victoria Fox would be completely alone with Phoenix. The 4-week-old infant was left in her care. No one else was in the home. No one was watching. For the first time since Fox arrived, she had complete privacy with the baby. What happened next occurred behind closed doors, but medical evidence would later tell the story. Fox violently shook Phoenix. She squeezed him. She threw him down on a bed. The infant's small body could not withstand the force of the assault. He sustained catastrophic injuries. After inflicting this violence on the helpless baby, Fox went downstairs to eat lunch. She left Phoenix upstairs, dying from his injuries. She did not call for help. She did not alert the parents at the hospital. She simply went about having her meal while the 4-week-old lay suffering above her. When the parents returned home with their newborn twins, they discovered Phoenix in distress. They rushed him to medical care, but the damage was too severe. Phoenix died within a day of his injuries. Medical staff examined the infant and found evidence consistent with violent shaking and impact. This was not an accidental fall or a sudden medical condition. This was inflicted trauma. The investigation focused immediately on Victoria Fox. She had been alone with Phoenix when he sustained his injuries. She was the only person who could explain what happened. During questioning, Fox admitted to what she had done. In a sentencing document, it was revealed that she confessed to violently shaking the baby, squeezing him, and throwing him down on the bed. She also admitted that she went downstairs to eat lunch as Phoenix lay dying upstairs. The confession left no doubt about what had occurred or who was responsible. Fox was arrested and charged with murder. The case moved through the San Diego County court system. Rather than go to trial, Fox entered a guilty plea. She admitted to killing Phoenix. By pleading guilty, she accepted responsibility for the infant's death and faced sentencing. On March 1, 2023, Victoria Fox stood before a San Diego County judge for sentencing. Deputy District Attorney Ramona McCarthy spoke about what Fox had done and the impact on the family. The parents, who had done everything they thought was right to protect their children, had lost their son. They had vetted Fox, checked her references, flown her to San Diego, and given her a trial period with supervision. Yet the moment she was alone with Phoenix, she killed him. The judge sentenced Fox to 25 years to life in prison. Under California law, this meant she would serve a minimum of 25 years before becoming eligible for parole. She would be in her mid-60s before she could even apply for release. Whether she would ever be freed would depend on the parole board's assessment decades in the future. After sentencing, the parents released a statement. They expressed gratitude for the support they had received from investigating officers and the prosecutor's office. They said they thought of Phoenix every day and that the horrific event still affected them deeply as a family. They hoped the sentence meant no other family or child would experience what they had been through at the hands of Victoria Fox. The case raised devastating questions about how parents can protect their children. This family had done everything experts recommend. They vetted their nanny. They checked references. They conducted a trial period. They were cautious and careful, yet their son still died. What made the case particularly chilling was the timing. Fox had been in the home for days without incident. She had been observed caring for Phoenix under the parent's supervision. She had behaved appropriately during that entire time. Only when she was truly alone with the infant, when no one could see what she was doing and no one could intervene, did her violence emerge. This suggested that Fox was capable of controlling her behavior when being watched. She could present herself as a competent, caring nanny as long as eyes were on her. But when the surveillance ended, when she had complete privacy and power over a helpless infant, she revealed her true nature. The mask came off. The parents had to grapple with terrible questions. Had there been warning signs they missed? Could they have done anything differently? Should they have extended the supervised period longer? These questions haunted them, but the reality was that no amount of supervision during a trial period can guarantee what someone will do when truly alone. 4-week-old Phoenix had barely begun his life. He had not yet smiled his first social smile or lifted his head. He had not experienced anything beyond eating, sleeping, and being held. His entire existence had been 1 month of dependency on the adults around him. When his parents left to welcome his twin siblings into the world, they entrusted his care to someone they believed they could trust. They came home to find him dying. Victoria Fox is now serving her sentence in a California prison. She will be elderly before she has any chance of release. Phoenix's parents went from expecting to raise 3 children to having only 2. The twins grew up knowing they had an older brother who died before they ever met him. The family had to explain, as the twins got older, what happened to Phoenix and why he was not there. The case demonstrated an uncomfortable truth about child care. Perfect vetting does not guarantee safety. References can be fabricated or misleading. People can control their behavior during supervised trial periods. Some individuals are skilled at presenting false versions of themselves until they have the opportunity and privacy to act on violent impulses. This does not mean parents should not vet caregivers or check references or conduct trial periods. These precautions remain essential. But the case of Victoria Fox showed that even when everything is done right, tragedy can still occur. Some predators are simply too skilled at hiding their nature until they have access to vulnerable victims behind closed doors. Phoenix died because Victoria Fox chose violence over care in the moment she was entrusted with his life. No amount of preparation by his parents could have predicted that choice or prevented it once Fox was alone with him. The family did everything they could to protect their son, and he died anyway. That is the most devastating aspect of this case. The absolute futility of their precautions against someone determined to hide her true nature until the perfect moment to strike. Case 8. Denise Michelle Goodwin. By her late 30s, Denise Michelle Goodwin's life had not turned out as she had hoped. She was divorced with a teenage son still living with her mother, Helen Locke, in a rural area northeast of San Diego. She worked as an assistant at an animal hospital and also helped with her mother's business, which provided fiduciary services, managing finances, and legal matters for clients who could not do so themselves. This work gave Goodwin intimate knowledge of probate law, wills, and trusts. It also gave her access to vulnerable people with substantial assets. An elderly man named Seward Norris lived on Locke's property. He suffered from dementia, and Goodwin occasionally worked for him as a caregiver. In 2009, Goodwin contacted Norris's life insurance provider, pretending to be his daughter or granddaughter. She had the company cut a check for more than $44,000. She deposited the money into Norris's bank account, to which she had added her own name, and then spent the money on herself. This embezzlement went undetected at the time. It was a crime of opportunity that worked, and it established a pattern Goodwin would follow with her next victims. Goodwin decided to pursue caregiving work more seriously. She applied for a position with a company that provided services to seniors still living in their own homes. On her application, she lied about her education level and prior work experience, fabricating credentials to make herself appear more qualified. After being hired, she made a specific request. She wanted hospice work, caring for people dealing with end-of-life issues. The company granted her request, not knowing they were placing her exactly where she wanted to be, alone with dying people and their grieving families. In September 2010, Goodwin was assigned her first hospice case. She was hired to provide care for Carolyn Rayborn, a 91-year-old woman dying from lung cancer. Carolyn lived with her husband Gerald, an 88-year-old retired mapmaker. Gerald was in good health for his age and was known by friends and family as a health nut and a miser who had saved a substantial nest egg over the years. Carolyn and Gerald had married in the 1980s, a second marriage for both, and had been together for 3 decades. Goodwin moved into the Reborn home to provide around-the-clock hospice care for Carolyn. She gained the couple's trust during this vulnerable time. She was there during Carolyn's final weeks, witnessing the intimate moments of a marriage ending in death. She saw Gerald's devotion to his dying wife. She also took inventory of their assets and understood exactly how much money Gerald had accumulated. Carolyn Rayborn died in November 2010. Her death from lung cancer was expected and natural. There was no reason for anyone to suspect Goodwin of wrongdoing in relation to Carolyn's death. The hospice contract ended with Carolyn's passing. Goodwin should have moved on to another assignment. Instead, Goodwin solidified her hold on Gerald Rayborn's life and finances. Gerald was devastated by the loss of his wife of 30 years. He was 88 years old, emotionally shattered, and vulnerable to manipulation. Goodwin claimed she would continue to take care of him free of charge, despite her work contract having ended. She presented herself as a caring friend who wanted to help him through his grief. Over the following 3 weeks, Gerald signed over nearly all his assets to Goodwin. Some of these transfers may have been done willingly by a grieving man who trusted the woman who had cared for his dying wife. Others involved Goodwin's subterfuge and manipulation. The day after Carolyn's death, Gerald signed a quit-claim deed giving Goodwin the ability to sell the couple's home. A week later, he met with his estate planner and made Goodwin the successor trustee of his estate, giving her authority to make decisions about his assets if he became incapacitated or died. Through their joint bank account, Goodwin now had access to Gerald's $3,000 monthly pension. She forged checks in his name. She systematically drained his accounts. Gerald had saved approximately $600,000 over his lifetime, and Goodwin began spending it on herself. In November 2012, 2 years after Carolyn's death, and after Goodwin had secured control of Gerald's assets, she decided Gerald had outlived his usefulness. She suffocated the 88-year-old man with a plastic bag. Gerald Reborn died alone in the home he had shared with Carolyn, killed by the woman he had trusted to care for both of them. Goodwin's plan might have worked if not for suspicious family members and investigators who began looking into Gerald's finances and the circumstances of his death. They discovered the rapid transfer of assets to Goodwin immediately after Carolyn's death. They found evidence of forgery. They uncovered Goodwin's lies on her employment application, and medical examiners determined that Gerald's death was not natural. San Diego County prosecutors charged Goodwin with first-degree murder with the special circumstance of murder for financial gain. This charge carried a potential sentence of life without parole or the death penalty. She was also charged with caretaker theft from an elder adult, fraudulent appropriation by a trustee, grand theft of personal property, and forgery. The case went to trial. Prosecutors presented evidence of Goodwin's calculated predation on the Reborns. They showed how she had lied to get the hospice job, how she had specifically requested end-of-life cases, how she had manipulated a grieving widower, and how she had murdered him after draining his life savings. They also presented evidence of her earlier embezzlement from Seward Norris, establishing a pattern of financial crimes against elderly victims. After 4 days of deliberations, the jury found Goodwin guilty of first-degree murder with the special circumstance allegation of murder for financial gain. They also convicted her on all the fraud and theft charges. The special circumstance finding meant Goodwin would face either life without parole or the death penalty. Goodwin's defense team acknowledged the evidence of fraud and theft, but had insisted murder was beyond her. During the penalty phase, they requested the murder conviction be reduced to second-degree murder. The motion was denied. On January 30, 2015, Goodwin was sentenced to life in prison without the possibility of parole. At her sentencing, Deputy District Attorney Bill Mitchell described her in terms that captured the essence of her crimes. He called her a thief disguised as a churchgoer and a killer disguised as a caregiver. She had presented herself as a religious, caring person while systematically robbing and ultimately murdering vulnerable elderly people. Denise Michelle Goodwin is now serving life without parole in a California prison. She will never be released. She will spend the rest of her life behind bars, where she can no longer prey on the elderly and grieving. The Rayburn case exposed dangerous vulnerabilities in the system meant to protect seniors. Goodwin had lied on her job application, but no one verified her credentials thoroughly. She had embezzled from Seward Norris, but that crime was not discovered until after she had moved on to victimize the Reborns. She specifically requested hospice assignments, putting herself in close contact with dying people and their surviving spouses. Yet no one questioned why she preferred these cases. Hospice care requires caregivers to enter homes during the most vulnerable times in families' lives. The dying person is often heavily medicated and unable to monitor what is happening around them. Family members are consumed with grief and making end-of-life decisions. Financial and legal matters may be handled hastily as death approaches. These circumstances create perfect opportunities for predators like Goodwin. Gerald Reborn was by all accounts a careful man with money. He had worked his entire life and saved diligently. He was described as a miser, someone who watched every penny. Yet, in the 3 weeks after his wife's death, he signed over his home and made his hospice worker the trustee of his estate. This dramatic change in behavior suggested either that Goodwin was extremely skilled at manipulation or that Gerald's grief left him unable to think clearly about the decisions he was making. The progression from embezzlement to murder showed Goodwin's escalating criminal behavior. She started by stealing from Seward Norris, a man with dementia who might not notice the missing money. When that worked, she sought out more opportunities through hospice work. She stole from Gerald Reborn while he was alive, forging checks and draining accounts. Finally, when she had taken everything she could, and Gerald became more of a liability than an asset, she killed him. The plastic bag method of suffocation was brutally simple. It required no special knowledge or tools. It could be done quickly in a private home where an elderly person lived alone. And if Goodwin had been more careful about covering her financial tracks, Gerald's death might have been attributed to natural causes. An 88-year-old man dying at home would not automatically trigger a homicide investigation, but investigators did look closely, and they found the truth. They discovered Goodwin's pattern of lies and theft. They uncovered the suspicious timing of asset transfers. They determined Gerald had been murdered, and they built a case strong enough to convince a jury that this caregiver was a calculating killer who had murdered for money. Carolyn Reborn died of lung cancer, believing the woman caring for her was kind and trustworthy. Gerald Reborn died at the hands of that same woman after she had systematically robbed him of everything he had spent a lifetime building. Neither of them could have imagined that the person they invited into their home during their most vulnerable time would steal from them and commit murder. The case remains a stark warning about the dangers faced by elderly people who require in-home care, particularly during end-of-life situations. Background checks must be thorough and verified. Financial changes made shortly after a spouse's death should be scrutinized. And families must remain vigilant even when a caregiver seems trustworthy, because, as Denise Michelle Goodwin proved, some predators are very skilled at wearing the mask of compassion while calculating how much they can steal and whether murder will help them get away with it. Case 9. Elizabeth Wetlaufer, Elizabeth Tracy, May. Wetlaufer was born on June 10, 1967, and raised in Zora Township, a rural community near Woodstock, Ontario. She grew up in a staunchly Baptist household and went on to earn a bachelor's degree in religious education counseling from London Baptist Bible College after graduating from high school in the mid-1980s. She then studied nursing at Conestoga College and became a registered nurse. By all outward appearances, she was educated, religious, and dedicated to caring for others. In 2007, Wetlaufer was hired onto the staff at Carescent Care, a long-term care home in Woodstock, Ontario. She was 40 years old and beginning what would become a 9-year killing spree that would make her one of the deadliest serial killers in Canadian history. The victims were elderly nursing home residents, people in the final years of their lives who had been placed in Wetlaufer's care by families who trusted the system to keep them safe. Wetlaufer's method was consistent and difficult to detect. She injected her victims with insulin overdoses. Insulin, when administered in excessive amounts to people who are not diabetic or who do not need such large doses, causes blood sugar to drop dangerously low. This can lead to confusion, seizures, coma, and death. In elderly patients with multiple health conditions, an insulin-induced death could easily be mistaken for natural causes. No one would necessarily think to test for insulin levels in an elderly nursing home resident who died. Between 2007 and 2014, While working at Carasant Care in Woodstock, Wetlaufer killed at least 7 residents. She also attempted to kill 2 others by injecting them with insulin with intent to murder, though they survived. The victims ranged in age from their 60s to their 80s. They were vulnerable people with conditions like Alzheimer's disease and other ailments that had brought them to the nursing home. They could not protect themselves or report what was happening to them. In 2014, Wetlaufer left her full-time position at Carasant Care. The circumstances of her departure would later become a subject of intense scrutiny. She had been the subject of complaints about her work performance and unsafe practices. The College of Nurses of Ontario, the regulatory body for nurses in the province, had received reports about her. Yet when she left Carasant Care, it was negotiated with the support of the Ontario Nurses Association that she would not have a mark on her record. The long-term care facility was not allowed to share information about the complaints with future employers. This protection of Wetlaufer's employment record meant she could continue working as a nurse at other facilities. She took part-time positions at other nursing homes and provided care in patients' private residences. At Meadow Park facility in London, Ontario, she killed 75-year-old Arpad Horvath. At a retirement home in Paris, Ontario, she injected 77-year-old Sandra Towler with intent to murder. At a private residence in Ingersoll, Ontario, she injected 68-year-old Beverly Bertram with intent to murder. Both Towler and Bertram survived. What made Wetlaufer's case particularly disturbing was not just the number of people she killed or attempted to kill, but the fact that she confessed repeatedly over the years and no one reported her to police. She told a lawyer what she had done. She told friends. She told a former partner. She told her pastor. Some people advised her to keep it a secret. Others simply did not believe her or did not take her seriously. No one contacted law enforcement. The killing continued. Wetlaufer later told police she had tried to stop killing and had sought help by telling people what she had done. She described hearing laughter that prompted her to commit the murders, though she clarified this was not audible laughter, but a feeling in her chest, while the urge to kill came from her stomach region. She never claimed to derive pleasure from the killings. She stated she felt horrible after murdering each victim. Yet the compulsion continued, and despite her confessions to multiple people, no intervention occurred. The breakthrough came in September 2016 when Wetlaufer voluntarily entered an inpatient drug rehabilitation program at the Centre for Addiction and Mental Health in Toronto. On September 16, 2016, she checked herself in for treatment. During her time there, she confessed to CAM staff about killing or attempting to kill her patients. This time, the confession was taken seriously. CAM staff notified the College of Nurses of Ontario and the Toronto Police Service. Wetlaufer then sent an email to the College of Nurses to resign as a registered nurse, stating she had deliberately harmed patients in her care and was now being investigated by the police for same. She personally called an investigator from the College of Nurses. She had CAM staff fax a 4-page handwritten confession. On July 20, 2016, during a taped interview at CAM, Wetlaufer provided a detailed 2-hour-long confession to police. She admitted to killing 8 patients and attempting to kill 6 others. She provided specific details about the victims, the dates, and the methods. After further investigation, she was formally charged with 8 counts of murder on October 25, 2016. On January 13, 2017, additional charges were filed: 4 counts of attempted murder and 2 counts of aggravated assault. Wetlaufer waived her right to a preliminary hearing. On June 1, 2017, she stood before the court and confessed to all charges. She pleaded guilty to 8 counts of first-degree murder, 4 counts of attempted murder, and 2 counts of aggravated assault. There would be no trial, no opportunity for her lawyers to mount a defense. She admitted everything On June 26, 2017, less than a year after her confession at KMH, Wetlaufer was sentenced. She received 8 concurrent life terms in prison with no possibility of parole for 25 years. Her earliest possible release date is 2042, when she would be 75 years old. The victims' families attended the sentencing. They had lost mothers, fathers, grandparents. Some had suspected something was wrong when their loved ones died, but had been told it was natural causes. Others had never questioned it until police contacted them years later to say their family member had been murdered by a nurse. The province of Ontario responded to the case by commissioning a public inquiry. On the day of Wetlaufer's sentencing, Attorney General Yassir Naqvi and Minister of Health and Long-Term Care Eric Hoskins jointly announced the inquiry. The goal was to understand how Wetlaufer had been able to kill for so long without being stopped, and to identify systemic changes needed to prevent similar cases in the future. The inquiry revealed multiple layers of failure. Wetlaufer had confessed to a lawyer who advised her to keep it secret and did not report it. This raised questions about lawyer-client privilege versus duty to report ongoing danger to others. She had told friends, a former partner, and a pastor, none of whom contacted authorities. This highlighted how people sometimes dismiss confessions as exaggerations or cries for help rather than literal admissions of murder. The College of Nurses had received complaints about Wetlaufer's unsafe practices, but had not prevented her from continuing to work. When she left Coruscant Care, the Ontario Nurses Association negotiated to keep her record clean, allowing her to work at other facilities where she killed again. This exposed problems with how professional regulatory bodies handle complaints and share information about dangerous practitioners. Hiring and firing practices at long-term care facilities came under scrutiny. Background checks were sometimes minimal. Poorly performing or unsafe staff might be tolerated because of workforce shortages. References were not always thoroughly checked. The inquiry heard that Wetlaufer would not have been caught if she had not confessed, suggesting that detection systems for this type of crime were essentially non-existent. The case also raised broader questions about healthcare serial murder. Patients and families place enormous trust in caregivers, particularly in institutional settings like nursing homes. Most people would not consider the possibility that a nurse might be intentionally killing patients. The status of healthcare professionals places them above suspicion. When elderly patients with multiple health conditions die, natural causes are assumed. Without a reason to suspect foul play, insulin levels are not tested, and murders go undetected. Wetlaufer's religious background added another troubling dimension. She had studied religious education and came from a deeply Baptist family. She worked in a helping profession. She was supposed to embody compassion and care. Yet she systematically murdered vulnerable elderly people over nearly a decade. The disconnect between her background and her actions was profound. The inquiry ultimately concluded that systemic changes were needed in how long-term care facilities operate, how professional organizations handle complaints, how information is shared between employers, and how healthcare workers are monitored for signs of harm to patients. The College of Nurses revised policies related to complaints. Legislation was proposed to address gaps in oversight and accountability. Elizabeth Wetlaufer was initially held at Grand Valley Institution for Women in Kitchener, Ontario. In March 2018, she was transferred to a secure facility in Montreal to receive medical treatment. She remains imprisoned, serving 8 concurrent life sentences. She will be eligible to apply for parole in 2042, but whether she will ever be released is uncertain. The families of her victims live with the knowledge that their loved ones were murdered by someone who was supposed to care for them. Some of the victims had been suffering from dementia or other conditions that made their final years difficult. Their families had placed them in nursing homes, hoping they would receive compassionate end-of-life care. Instead, they were murdered by a nurse who injected them with insulin overdoses. The case of Elizabeth Wetlaufer stands as one of the most significant failures of the healthcare system and professional oversight in Canadian history. A nurse confessed repeatedly to multiple people over multiple years, and no one stopped her. She killed 8 people and harmed 6 others. The victims were among society's most vulnerable, elderly, ill, dependent on others for their most basic needs. They died at the hands of someone wearing a nurse's uniform, someone their families trusted to keep them safe and comfortable in their final days. The inquiry's findings and the systemic changes it prompted may prevent future Elizabeth Wetlaufers, but for the families of the 8 people she murdered, those changes came too late. Their loved ones are gone, killed by a nurse who operated with impunity for nearly a decade while confessing her crimes to anyone who would listen, waiting for someone to finally take her seriously and stop her. Case 10. Gwendolyn Graham. In 1986, Gwendolyn Gale Graham moved from Texas to Walker, Michigan, a suburb of Grand Rapids, and found employment at the Alpine Manor nursing home. She was hired as a nurse's aide, providing basic care to elderly residents. Her supervisor was Catherine May Wood, a recently divorced woman who had gained considerable weight and was, by her own later account, hungry for friendship and connection. When Graham and Wood met, they quickly became close. Before long, their relationship became romantic. They were lovers working together in a nursing home filled with vulnerable elderly residents. What happened next would become one of the most disturbing cases of healthcare serial murder in American history. According to Wood's later testimony, Graham began talking about committing murder as a twisted form of bonding. The idea was that killing together would create a secret that bound them forever, something that only the 2 of them shared. Wood agreed to participate, though she would later claim she was dominated and manipulated by Graham. The 2 women turned the selection of victims into a game. They decided to choose elderly residents whose initials would collectively spell the word M-U-R-D-E-R. This macabre game was meant to add structure to their killing spree. The first intended victim fought back harder than expected, so they abandoned the spelling plan. Instead, they simply focused on the weakest and most vulnerable women in the nursing home. Many of the victims suffered from Alzheimer's disease. They ranged in age from 65 to 97. They were incapacitated and unable to defend themselves or call for help. They were entirely dependent on the staff at Alpine Manor to keep them safe. Instead, Graham and Wood targeted them for murder. According to Wood's account, Graham was the one who carried out the actual killings. She would enter a victim's room and suffocate them with a washcloth while Wood stood guard outside or distracted supervisors. The method was simple and left little evidence. An elderly nursing home resident dying overnight would not automatically trigger suspicion. Deaths in nursing homes are common, and without reason to suspect foul play, autopsies are rarely performed. Between January and February 1987, Graham murdered 5 women. Wood later testified that Graham took souvenirs from the victims, keeping items to relive the deaths. However, no such souvenirs were ever discovered by police, raising questions about whether Wood's account was entirely accurate or whether she was embellishing details to make Graham appear more monstrous. What made the case particularly disturbing was that both women openly bragged about the murders to their co-workers. Graham allegedly showed off the souvenirs she had taken from victims. They talked about smothering elderly residents. They made their crimes known to the people they worked with every day. But no one believed them. Co-workers thought they were making sick jokes or playing twisted pranks. The idea that 2 nurses' aides would actually murder patients seemed too outlandish to be real. Graham and Wood's relationship was volatile. Wood portrayed Graham as sexually, physically, and emotionally dominant. She testified that Graham was possessive and controlling. They would play odd pranks together, like lying under patients' beds and grabbing other nurses' aides by their ankles as they walked by. Co-workers described their relationship as intense and unhealthy. At one point, they got into a fight, and Graham dragged Wood into a bedroom by her hair. Wood also later told a version of the murder planning that involved counting each killing as a day, as in the phrase, "I will love you forever and a day." A poem Wood wrote to Graham, which was introduced at trial, concluded with the line, "You'll be mine forever and 5 days," suggesting 5 murders. The relationship ended when Graham began dating another female nursing aide who also worked at Alpine Manor. The breakup occurred after Wood refused Graham's demand that she actively kill a patient herself to prove her love. Wood had been willing to stand guard and help cover up the murders, but she drew a line at personally suffocating someone. Graham took this as a betrayal and moved on to another woman. After the breakup, Graham moved back to Texas with her new girlfriend. She began working in a hospital, caring for infants. The thought of Graham, who had murdered 5 elderly women, now working in a neonatal ward, was chilling. She had access to the most vulnerable patients imaginable, newborn babies. Meanwhile, Wood transferred to another shift at Alpine Manor and continued working there. She carried the secret of the murders with her. Then, in late 1988, she made a decision that would finally bring the case to light. She told her ex-husband, Ken Wood, what she and Graham had done. Ken immediately contacted the Walker Police Department. Detectives were initially skeptical. The story seemed almost too bizarre to believe. But they began investigating. They spoke with the administrator of Alpine Manor, who reported nothing unusual and said Wood was an excellent employee. They then interviewed Wood, who initially claimed it was just a joke. Under continued questioning, she changed her story and began providing details about the murders. Wood claimed Graham had suffocated multiple patients while Wood kept watch. She described the victims, the methods, and the timeline. Investigators exhumed bodies and re-examined medical records. Although they could find no direct physical evidence linking Graham and Wood to the deaths, the bodies were too decomposed and no one had suspected murder at the time, they had Wood's detailed confession and testimony. In December 1988, both women were arrested. Wood quickly agreed to cooperate with prosecutors in exchange for a reduced sentence. She would testify against Graham in exchange for pleading guilty to lesser charges. This cooperation would ultimately result in Wood receiving 20 to 40 years in prison, while Graham faced life without parole. Graham's trial took place in 1989. Wood was the star witness, describing in detail how Graham had planned and carried out the murders. Graham maintained her innocence throughout the trial. She claimed the entire story was an elaborate mind game by Wood, a fabrication designed to punish Graham for leaving her for another woman. Some people, including journalist Lowell Cowfield, who wrote a book about the case, questioned Wood's account and her motivations. Wood had told multiple versions of events to different people. She told some inmates that she had made up the entire story to get revenge on Graham. She told others that she was actually the one who committed all the killings and framed Graham. These conflicting accounts raised doubts about her credibility. However, the prosecution had more than just Wood's testimony. Graham's new girlfriend testified that Graham had admitted to killing 5 people while they were together in Texas. This corroboration from someone who had no apparent reason to lie proved crucial to the prosecution's case. On September 20, 1989, the jury found Gwendolyn Graham guilty of 5 counts of first-degree murder and 1 count of conspiracy to commit murder. On November 2, 1989, she was sentenced to 5 consecutive life terms without the possibility of parole. She was 26 years old. Catherine Wood pleaded guilty to 1 count of conspiracy to commit murder and 1 count of second-degree murder. She was sentenced to 20 to 40 years in prison. She became eligible for parole after serving 20 years, but was denied 8 times before finally being granted parole in October 2018. She was released on January 16, 2020, after serving 30 years. She moved to South Carolina to live with family. The families of the victims were devastated. They had placed their mothers, grandmothers, and great-grandmothers in Alpine Manor, believing they would be cared for in their final years. Instead, their loved ones were murdered by staff members who turned killing into a twisted game. Several families sued the owners of Alpine Manor for hiring dangerous and unbalanced employees. The nursing home eventually went out of business. The building now houses a facility called Sanctuary at St. Mary's. The case raised disturbing questions about oversight in nursing homes. How had Graham and Wood been able to murder 5 people without being detected? Why had no one taken their boasts seriously? What warning signs were missed during the hiring process? The answer was that nothing in Graham or Wood's backgrounds clearly predicted they would become killers. They had no criminal records. They had gotten their jobs through normal channels. And when they bragged about the murders, co-workers dismissed it as dark humor or attention-seeking behavior. The idea that nurses' aides would actually murder patients seemed too outlandish to be true. The deaths themselves had not raised alarms because elderly nursing home residents with Alzheimer's disease die regularly. Without a reason to suspect foul play, deaths were attributed to natural causes. No one thought to test for suffocation or look for evidence of homicide. The perfect victims, from a killer's perspective, were people whose deaths would not seem suspicious. Gwendolyn Graham remains imprisoned at the Women's Huron Valley Correctional Facility in Michigan. She is now in her 60s. She will never be released. She will die in prison, having spent most of her adult life incarcerated for the murders she committed when she was in her early 20s. The case has been featured in numerous documentaries and true crime programs. It was the basis for a book titled Forever and 5 Days by Lowell Caulfield. The television series American Horror Story included a highly fictionalized version of the story in its 6th season. The case appeared on episodes of various true crime shows exploring serial killers and killer couples. For the families of the 5 elderly women who died, no media coverage or legal resolution could restore what was taken. Marguerite Chambers, Mae Mason, Myrtle Luce, Edith Cook, and Belle Burkhard were the 5 confirmed victims. They were mothers, grandmothers, and great-grandmothers. They had lived long lives and ended up in Alpine Manor because they needed care in their final years. They died because 2 nurses' aides decided to turn murder into a bonding experience and a twisted game. The case stands as a reminder that the greatest danger to vulnerable people often comes not from strangers, but from those entrusted with their care. Gwendolyn Graham and Catherine Wood wore nurses' aide uniforms and were given access to helpless elderly women. They exploited that access to commit murder, and they got away with it for months because no one could imagine that caregivers would deliberately kill the people they were supposed to protect. By the time anyone took their boasts seriously, 5 elderly women were already dead. These 10 cases span decades, continents, and victim types, yet share a devastating common thread: the betrayal of society's most sacred trust. Whether caring for helpless infants, vulnerable elderly, or disabled adults, these predators weaponize the access and authority society granted them. Some killed for money, others from rage or jealousy. A few claimed voices or love bonds drove them, but all exploited the fundamental human need for caregiving. The victims, from 10-week-old infants to 97-year-old nursing home residents, shared only their defenselessness and their families' tragic belief that caregivers could be trusted. Their deaths demand more than justice. They require systematic reform in how we vet, monitor, and hold accountable those we entrust with our most vulnerable loved ones. Which of these cases shocked you most? Do you think the current system does enough to protect children and the elderly from dangerous caregivers? Share your thoughts in the comments below, And don't forget to like and subscribe for more true crime coverage that examines the betrayals that shake our faith in humanity.